This segment is going to concern video depositions, and we're going to start by talking about videotaping the helpful witness, that is, the witness who is helpful to your side of the case. And certainly if the video is well done, you would expect that the video would be more effective than simply reading into the record the question and answer from that same witness. Even if you got an actor to play the witness and so on, there is a world of difference between reading testimony and actually seeing the person give that testimony. One judge, in fact, described reading the Q&A as an act of contributory somnolescence. So that will give you some idea of how effective or ineffective that is. That said, think about it. Not every deponent is attractive, well-spoken, making a case on his or her own behalf. I have seen cases where people have made an advertent decision. Reading the Q&A may not be great, but it is in fact better than this guy. There is room for using your imagination in taking a video deposition, and instead of saying, well, I've been at video depositions and I understand the drill. There's typically the camera on the witness and things roll along from there, and that's the way it goes. There are other things that you might do, and they don't require great imagination. They just require that you think about it. By way of analogy, a few years ago, in reading the obituary for Desi Arnaz of I Love Lucy fame, I learned that one of the things that he did was he was the first person to use two cameras to film a sitcom for TV. By hindsight, you say, well, it's obvious. Well, yeah, it is. A lot of excellent ideas are obvious by hindsight. The trick is to try to think of something ahead of time that will make things more effective. I know of at least one instance where the video was more effective than having the witness come in and testify live. This was a case that was tried in Philadelphia some years ago. Jerry Litvin, a fellow of the college, represented the plaintiff in the case, and it involved a very serious injury to a hand. Jerry was going to have the surgeon who had performed the surgeries come in and testify. The case was postponed for a week. The doctor was going to Japan on a trip he could not or would not cancel, and so you're faced with a situation where you have to take the video deposition. And a number of things were done in that video. It was truly a multimedia presentation to make it more effective. But one of the things that happened was, at some point, the doctor began to describe what he did. And he had what at first appeared to be the model of a hand in front of him. And he was pointing out that the incision had been made here, he had taken a flap there, he had done this, he had done the other thing, and you could see what looked like a model of a badly deformed hand. And then you realized that it's not a model at all. This is the plaintiff's hand, and the plaintiff is right here but off screen. You never saw the plaintiff himself, you just saw his hand, and the doctor went through showing step by step what was done. And Jerry remarked after the fact that the only way that he could have done that with equal effectiveness in the courtroom would be if the judge would let him and the doctor and the plaintiff climb into the jury box and show exactly what was being done. And if the judge had allowed that, he said it would have been too grisly for some jurors because the injury was just so bad. And again, after the fact, you don't have to be a genius to think about having the hand there and having the doctor do it. What better way to show the injury? But you do need to take some time and think, is there a way to make it more effective here? It may mean going to the scene of an accident. I've seen videos taken that way. It may mean in a product liability case, videoing the machine, the punch press at issue, and if it's and even to the point of having a reenactment, not something that's going to put anybody at danger, obviously, but to actually show the piece of equipment in operation. You might think about an interview style. In one case, the witness was a fellow who was just as dry and drab and unimpressive as could be. He had excellent credentials, but he just faded into the background, and particularly when the camera did not look. And so the lawyer who was taking his deposition set things up interview style so that the witness was here facing the camera, and the lawyer asking the question was smack dab right against him. It was the plaintiff's lawyer, and he invited defense counsel to be in the picture too. Defense counsel demurred, said no, and so they went ahead that way. Well, the witness was forced to look at the camera because it is so terribly uncomfortable to turn this way and talk to somebody who is smack dab against you. Again, the message, think about it. There are some mechanical things to keep in mind. The witness's appearance. Does he have, at 4 o'clock in the afternoon, the proverbial 5 o'clock shadow? There's nothing wrong with asking him to get a shave and give him a shaving kit and come back. Is the witness wearing glasses? Are there even some people with a receding hairline where some powder may make the difference? What about the background? Is there anything distracting or comical? What about the foreground? Are there coffee cups and papers strewn about the table that detract from the formality? Do you need props? Do you need a shadow box for an x-ray? Do you need a model of an eye for the doctor to use? If you're going to use a document, do you have a chart to prop it up on? And have you spoken to the videographer ahead of time about the idea of getting a shot of that document up close and having and also being able to record the witness as he or she is testifying? I think it's a very good idea to monitor the action, because there are things that happen in a videotape deposition which are not apparent when you're in the larger room with the witness, but become very apparent when the video is shown. For example, if the witness is in a chair that twirls, you can turn it easily from side to side. Some people kind of lapse into a side-to-side motion like this where you don't notice it. You're looking right at him and you don't notice him because it's a big room. You put it on the video and you can't take your eyes off the fact that he's doing that. There can also be the problem of the shifty-eyed witness. And we all know that if somebody's shifty-eyed, they're not truthful. Well, it isn't always so. Again, going to a real case, in one case, my opponent was on this side of the table, the witness was here. He asked his questions, got the testimony he needed for trial, and now it's my turn to ask questions. I'm over here. And as I asked the question, the witness looked at me, and she did what a lot of people do instinctively. She would look back to the lawyer who was effectively her lawyer for moral support or for whatever. He was not doing anything. He wasn't giving any cues or whatever. but the entire cross-examination went like this, and she looked like a shifty-eyed witness. So it's a good idea at maybe more than one point during the deposition to ask the videographer to stop and show me the last 2 minutes. You're not on a fast train that's going downhill where you can't get off. You can get off, you can stop it, you can say, show me the last 2 minutes. If you detect something like that, you can just move on the other side of the table, and that will stop the shifty-eyed performance. If you see the twirling witness, you get him a chair that doesn't twirl, you make the adjustment. The biggest complaint about videotape depositions is that they are boring. That is the biggest complaint from jurors. So whichever side you're on, you want to get to the point. It's quickly. Direct examination, cross-examination, redirect. We can talk about how it gets used at trial in a moment, but make it as effective as you can make it in the first instance. Let's talk about video recording the adversary witness or the adverse party, and that is becoming more the norm, at least in terms of the cases I'm handling and in terms of the lawyers I'm talking to.
Dennis, before you go on, can I add a few points about the videotaping of your friendly witness?
Absolutely.
Where what we're really talking about is the equivalent of perpetuating testimony, where we have a witness whose testimony we're going to offer at trial through the videotape, often or usually instead of live presentation. And many of Dennis's points are extremely important, and I want to add a couple of more. One is that in addition to, at some later point, monitoring the tape and that you going and asking to see a couple of minutes of what has been taking place, I suggest that before the tape starts rolling, you go and always look in the monitor to make sure that the setup and lighting is as you want it to be. Don't wait for 30 minutes or 15 minutes of what may be something that needed to be fixed before you're checking everything, and don't rely on the videographer for having adequately set up the camera and lighting and positioning in such a way that this particular witness is going to look as believable as you want the witness to look. Also, think about pacing of the questioning. When the decision is being made over what part of the deposition to actually show at trial, there's no necessity to show the whole thing. Frequently, we will edit to bring a longer deposition down into a shorter trial presentation. And it's important that there be a brief moment between the conclusion of the answer and the beginning of the next question, so that there will be a space for editing and allow clips to be edited without the end of the answer being apparent at the beginning of the question that you want to show. So always briefly pause after the witness has finished an answer before you start the next question in order to leave that editing space. When you get to trial and you are using that portion of the deposition that you have chosen to use, I suggest that all of these props or models or enlargements that you have chosen to use during the deposition, as Dennis has just suggested, be brought into the courtroom and set up next to the screen. So if there was an enlargement on an easel that the witness was pointing to, have that same enlargement on a similar easel next to the screen, so that when the jury is watching the doctor on video pointing to the diagram, that diagram is right there three-dimensional, in person, right in front of the jury, and it helps to bring them into what's going on, make it less boring and make it more real and informational. Certainly if there was a skeleton or other model, bring that model into the courtroom. Can't bring the hand in, although the hand will be there because the plaintiff is going to be there. If the witness is referring to an exhibit, then what you should do is have your technology people create a split screen editing of the video so that on one side of the screen the witness's testimony is being shown, but on the other side of the screen the document, the exhibit which is being referred to, is being enlarged and shown on the screen at the same time. So if the witness is shown a document and looking at the first page of Exhibit 6, Exhibit 6 first page should be projected on the screen on a split screen image. And then when the witness is referred to page 6 should put up on the screen. And when the witness is then referred to the second paragraph and is looking at a particular sentence, that paragraph should be blown out and the particular sentence should be highlighted or again enlarged. So in order to make it more informational and more interesting, whatever it is that can be more creative, both in the original setup in the video, also think about, as Dennis suggests, just think about how to make it more informational and more interesting if you also get creative about how to show it in the courtroom.
David, I agree with that point about the split screen, but one thing I've found is that no matter how big the TV, and we get some pretty big ones in the courtroom, is once you have the witness's head on half, the document is harder to look at, and it also requires a lot of lead time in the editing to get things right. And I've found that what most judges will let you do is have a second screen where you're projecting either from an Elmo or through the technology. And the thing that's useful there is you can have your technology person, your paralegal, as the witness is describing a section of the document, you can highlight it, they can bring it up in yellow or enlarge it, and it really does bring a little bit of variety, because the one dreadful thing about most depositions video is that a talking head that doesn't have anything
Absolutely.
else to do is as Dennis said, it's the, I can't say that word, but it's exercise in
Sleepiness.
sleepiness.
Well, I agree that anything we can do to make the shooting of the deposition more informational and interesting, and then its portrayal in the courtroom, we ought to be thinking about, as Dennis says. As far as the screen, I'm a big fan of using our modern projector technology to, rather than using even large television screens, using a large projected screen in the
that's
courtroom.
what I meant, yeah.
Not every courtroom will allow for that, and some courtrooms have video monitors already established within the courtroom, and they're, like you say, having the video monitor showing the video deposition and a second Elmo or other enlargement being portrayed to keep the jury occupied in what's going on, get them engaged in trying to see the process rather than their sleepiness of watching 30 to 60 minutes just go by.
Yeah, I might say that what we're offering in this program is something of an overview of this area. There are full-day courses on video deposition, so hopefully this will be helpful, but keep in mind that it is not the universe of what is out there to be learned. I might say, too, that in terms of getting the witness to look at the camera, when answering the question, there's one lawyer I know who regularly stands next to the camera when he asks his questions, and so the witness is naturally, in looking at him, is looking at the camera, and that really works quite well. Video recording the adversary witness. When we're recording the helpful witness, helpful to our side of the case, we want him or her to look good. When we're video recording the adversary witness, we're trying to make him or her look bad. And what you're trying to do is to get that sound bite, among other things, trying to get that sound bite that will be helpful to you in the courtroom. And so at the risk of some repetition, I would say, ask your key questions early. Use silences to your advantage. There are times when you will ask a witness what is obviously a hard question for the witness, and even though we're on opposite sides, there's a natural human inclination to be somewhat helpful to the witness, to explain what the question means, and to fill the silence with words. Don't do that. Just keep quiet and let the seconds go by, and let the witness sit there looking at what he's looking at and reading what he's reading or staring where he's staring, and ultimately the question will come. But the silence itself speaks volumes. We've talked elsewhere about the idea of not doing things in chronological order. That can be very important in cross-examining at a video deposition, because to what's most important. Also, there is good case law on the idea that the defendant, the counsel for the defendant, can require the plaintiff to participate in a reenactment of an accident if it involves a good-sized piece of machinery or whatever, so long as there is no danger to the plaintiff. But it is so much easier to get the facts clearly stated on the record by having the plaintiff there, by having a pointer that he or she can point to directly on this three-dimensional object and not be limited to this, that, or the other photograph, and trying to be clear that, yes, we have a compact, understandable statement of exactly what happened at the time of the accident. Preparing the witness for a video deposition, I think I will say only we're talking elsewhere in this program about preparing the deponent to testify. You may, in addition to everything else, want to use video more if there's going to be a video deposition. Particularly if the witness is not comfortable with that idea, and you don't have to do it for a long period of time. You just have to show the witness this is what it will be like, that's where the camera will be, and I think it is less of an issue today than it once was, because people are more used to the idea of a video being at a party, at a meeting, wherever. Using the video at trial, we've already talked about that to some extent, some very helpful comments made. So let me talk about some other points to keep in mind. First of all, if you're going to be the one sponsoring the video, you want to get objections ruled upon in advance of playing the video, and typically what the judge will require is, all right, either delete the objection and delete the answer that follows because there's no need for the jury to hear that, I'm sustaining the objection, or he may say, just delete the objection, the question was proper, we're just going to keep rolling. If the objection really matters, and typically, presumably it did, or you would not have made it, then you want to be sure that the record includes the full transcript that will show the question and answer for purposes of appeal. In terms of presenting the video in the courtroom, there's, I think, universal agreement that to be used effectively, you want the video to be short. And the only question is, how short? And there used to be judges who would require that the whole video be played no matter what. I think it's harder to find judges like that because they don't want to waste time either, and editing has become so much easier. So I've heard people say it shouldn't be longer than 25 minutes, shouldn't be longer than 12 minutes, it shouldn't be longer than 8 minutes. Whatever fits in your case, keep in mind that the objective is keep it short. There's a way of presenting the testimony which I think of as a kind of a docu-deposition, because it's presented as the way things are sometimes presented in TV documentaries. And so, for example, you may persuade the judge that the easiest, fastest, quickest way to get the defendant's or the witness's background or credentials or whatever on the record is to read a paragraph that accurately states what is in the deposition transcript and say, Dr. So-and-so gave this testified that his credentials were as follows. He graduated from, etc. And you can do that so much faster by reading a paragraph. You don't have to race through it, but by reading a paragraph than by Q&A over 15 pages. And it varies things. You can then say, let's suppose it's the treating physician. Dr. So-and-so testified this way about the plaintiff's condition when he first treated her, and then play the snippet of deposition testimony. You may be able then to intersperse it again with a summary and say, the doctor testified that he saw Mrs. So-and-so once a month for 6 months and treated her as follows. And he then testified about her condition at that point as follows. If what you propose to read accurately states what the doctor testified to, there's a very good chance that the judge is going to allow you to do that. Indeed, there's a very good chance that your opponent will cooperate in this kind of exercise because he's going to want to do the same kind of thing with his videotape testimony. There are a lot of things you can do, if you think about it, to make video testimony more effective at trial. Let's suppose you have a half dozen witnesses who testified about the same series of events. First of all, with respect to any single witness, what you might do is, let's say at 3 different places in his deposition, he testified about a meeting on January 20 of 2013. You might say to the jury, here is Mr. So-and-so's testimony about the meeting on January 20, 2013. It's taken from different parts of his deposition, but it all concerns that meeting. And then play those segments so that the jury hears all at once what this witness has to say. You can also do it with the half dozen witnesses that you're going to be presenting through video recording. That is, you can say, here is what Mr. A said about that meeting. Now here is what Mr. B said about that meeting. And there's been reference elsewhere in this program to the ABA standards on deposition practice. Those standards specifically give an imprimatur to that kind of use of the deposition testimony. It used to be unusual to have the transcript running at the bottom of the page as the witness testifies, but that's getting to be pretty much the norm. And I would say, too, that when you get to impeaching the witness, you would line things up exactly the way as if you had no video. I'm going to ask him about this, this, and this, and if he gives any answer different from what he said at his deposition, I have an easy reference to them, to the questions and answers. I'll be able to get to them immediately and confront him with them here and here and here. The only difference is with a video, the chances are that the recording will be on a laser disc where you can call up on the screen the question and answer immediately, and you can either do it yourself, you can have your colleague do it, you can have your video assistant do it, as long as you've worked things out ahead of time as to what testimony do I want to see on the screen at that point. Finally, I would say that you might give thought to using videos either in openings or closings. Using snippets of the video in closings, I think, is generally considered acceptable, at least in terms of the cases where I've been involved, because it's like reading testimony that the witness gave. It just so happens that you have it recorded. This assumes, of course, that it's part of the trial record and not just a deposition the guy gave somewhere or other. And this is an opportunity to organize that testimony and make it work for you. It shouldn't be your closing, but it can certainly be an aid to your closing. There have been recent cases where people have sought permission from the court to use videos in openings, video deposition testimony in openings. And I know of about 20 different cases where that request has been made, and in more than half of them, the trial judge allowed them to be used in openings. My own reaction was that should be okay, because the trial judge would let you read a short snippet from a deposition in your opening. What difference does it make if it's a video? I must say I changed my opinion after I actually saw them being used in an opening, because it became kind of like a 60 minutes indictment of the other side, not just, and it wasn't just saying, this is the evidence that I'm going to present, or this is what I'm going to prove. It was actually presenting it in the opening. It's not that you can't present it, but if I were a trial judge, I would not allow it. So, John, David?
Well, let me just describe what I think the two most common mistakes are in video use. Number one, we've already talked about, and that is that they're too long. I think the editing process has to be a multiple step, where the video is cut and then cut again and then finally cut again. And let me suggest that anything which is repetitive of other witnesses' testimony, or anything which is background, anything which is truly not controversial in controversy, or anything which is unimportant, even though it might have been used if the witness was there live in order to give context and position, testimony should be deleted. You want to focus the witness's video presentation on the key testimony and only the key testimony. get rid of the clutter. The second mistake, which I see a shockingly large amount of time, is the failure of the trial lawyer to have actually watched the video before it's shown. The trial lawyer, having participated in the deposition and having a memory of it, will edit on the transcript those Q&As that want to be shown, and then we'll have a paralegal or technology person create the video, and the final will not be viewed by the lawyer. Sometimes the lawyer claims, I don't have time. The judge, sometimes the editing doesn't occur until after the judge has ruled on admissibility. So it's in some sense, some cases during trial, that the final video is actually being spliced for presentation. I participated in a case a couple of years ago, multi-million-dollar bank liability case, where the plaintiff's attorney, I was the defense attorney, the plaintiff's attorney had taken the deposition of the key bank witness and had obtained what he thought was the single most important concession in the whole case. And he wanted to make certain that the testimony was being presented in exactly the way it was in the video. And so while he had subpoenaed the witness to come to trial, he suggested to me that he would release the witness from the subpoena if I would concede that the video could be used. The witness was not of a rank that would have made the witness a party opponent, and therefore the lawyer needed my stipulation. So I granted the stipulation. The witness disappeared from the case, and the lawyer was stuck with using only the deposition. Well, when the deposition was played, and in fact the crucial admissions of the case were contained in it, the video had obviously accidentally, the videographer had recorded rock and roll music that was somehow picked up on the tape. And it was hysterical. The courtroom was in laughter. The judge and jury were rolling in laughter, trying to listen to the testimony as recorded rock and roll music was coming onto the video at the same time. Obviously, the lawyer who was presenting the testimony had never bothered at any stage to actually view the video. All he had done was read the transcript, fall in love with the concessions, and assume that it was going to portray as well as he had remembered it at the time of the deposition. This was a multi-million-dollar, multi-week trial, and the 30-minute clip had never been watched by the lawyer. So the key points here, if you're going to use video at trial, is cut it, recut it, and watch it at these stages of cutting rather than just doing it on the transcript.
I agree with that, David. In fact, keeping it short is really something I consider very important, and I wonder how you guys handle it when the other side, of course, knows you want to keep it short, and so under the claim of for rule of completeness or whatever, they designate, as they normally have the right to do, they counter-designate large portions of the deposition so that when it's played, the hope is the jury won't notice the parts that you wanted to hear. And I find frequently the judges are not too interested in sitting back and going through the details of a deposition. They tell the lawyers to work it out and just bring me the parts that really need to be ruled upon. And I'm wondering what you do to try to avoid that, to get around the other guy loading up your good, short, pithy deposition segments with folderol that will put the jury to sleep.
Well, whenever the other side is attempting to disguise my important concessions with bury it within a lot of garbage that's contained in the deposition, I always insist that the other side's designations be treated as cross-examination would be treated, and that my presentation be shown as a separate cut, and then their presentations be shown as their cross-examination, and the jury be instructed that I am showing this portion and they are showing that portion, so the jury has reached its favorable conclusions from the small parts that I have seen, and they become upset at the other side because of the distraction and waste of time by the other side. Unfortunately, not all judges appreciate that. And the reality is, on occasion, some judges will make it all be cut together so that it's presented in chronological format in the order in which the testimony was actually given, even though some of it, very little of it, may have been my direct examination and most of it is the other side's cross. Then it can be helpful to have some manner of telling the jury what portion is being selected by each side, but even that is not nearly as effective as requiring that each side's designations be shown separately.
Yeah, I agree with that. So much depends upon the trial judge's willingness to actually get into the fray, and so often they are reluctant to do so. I think if you couple what David said with an appeal to the trial judge of saying, we have a bunch of witnesses who are going to be presented this way, and typically, Your Honor, I'm not going to take more than about 8 minutes for what I want to show, and if you might want to give some consideration to putting an outer limit on both sides. If I've got 8, let them have 3 times as much, but there's no reason in the world to bore this jury to death, etc. And if you can get them involved and engaged, you have a shot. Picking up, David, on your story about look at the videotape before you play it, some years ago, I saw that happen with an opponent who played the videotape of the plaintiff's treating physician, and it all went fine, except at the very end, when the videotape was over, as the 3 lawyers in the room understood, and we all started to sort of banter with one another. Well, we got through that. Where do you want to go? And so on and so forth. The usual bit. It wasn't catastrophic, obviously, by any means, but it just detracted from the formality and the seriousness, and you got the sense that the jury was going to say, this whole case is just lawyers being lawyers. It's
not real.
Yeah, and I think that is more likely to help the defendant than the plaintiff for obvious reasons.